Taylor makes 6.
7.
7. 1, 2,
Yes.
4.
Miss Allen is on.
Okay.
Well, Mr. Taylor, welcome.
Super T, welcome. How are you? I'd unmute the microphone.
How are you?
Good, yourself?
Good, thank you.
So all that's missing is Ms. Martinez, Mr. Benahan.
Correct.
Are we expecting anyone else?
Just Attorney Dugas.
And who's Attorney Dugan?
Attorney Dugas is our attorney.
Okay.
And here he comes.
Attorney Dugas, how are you?
Good. Hello, everybody.
Hi.
3, 2, 1.
This is a call to order of a special meeting of the Bridgeport Board of Education. Today is March 3rd, 2021. The time is noted as being 6:34 p.m. Secretary, would you call the roll?
John Weldon,
Present?
Bobby Brown,
Present.
Sybil Allen,
Here.
Albert Benahan, Jessica Martinez, Joseph Sepulveda,
Present.
Chris Taylor,
Here, Joe Lombard.
Zosimo Fabian,
Present.
myself, Joseph Lombard, present.
Okay, we have a quorum. Sole item on the agenda is consideration and possible action concerning termination of the contract of employment of Kathleen Smith. Before we go any further, I think maybe this is not something that occurs very often. So I'm going to ask Attorney Dugas to explain why it is that we're here and the laws that require this to occur.
Sure. As some of you may know, but for those of you who don't, when we talk about dismissing a teacher, there's a very specific statute that governs that process. It has nothing to do with the collective bargaining agreement. It has nothing to do with grievances. As a state statute, it's 10-151. And what it basically says that if the superintendent is considering, in his judgment, termination of a teacher is in order, then he must provide the teacher with written notification that termination of her employment is under consideration. Mr. Testani did that on February 8th in this particular case. Under the statute, the teacher then has 10 days to request a hearing. If that hearing happens, what would normally happen is it would either be a full hearing before the board, or it would be a hearing before an independent hearing officer. And 95% of the time, that is the options that teachers take. If it goes before an independent hearing officer, they issue a report, it comes back to you, and then you have to, and they issue a recommendation, either dismiss or not dismiss or something in between. And then you have to accept their findings, but you don't have to accept their recommendation. In this case, the teacher failed to request the hearing within 10 days. What that means legally is she has waived her right to a hearing either before you or before an independent hearing council. So that means that the superintendent can simply, well, there's two schools of thought. One, the superintendent can simply terminate her employment. I think the more cautious approach is that you take that step and take that action. So understand there has not been a hearing. There was an investigation of sorts, but there has not been a hearing. And because she has effectively waived her right to a hearing, we're simply asking you to affirm the superintendent's recommendation. And I will ask either from Ms. Alter-Dixon or Dr. Riallo to get into some of the specifics. For the benefit of the teacher, I think it's helpful that we not get into significant detail, but just to give you an overview of the basis.
Before we do that, I just want to ask, everybody was provided a file about this through the portal,
Yes,
and it describes a lot of the things that
Oh, okay, good.
brought us here. Has everybody read that?
yes, I did.
So did I.
Okay, Mr. Taylor, you have your hand up. You have a question?
Yes, Mr. Weldon, I apologize, Chairman Weldon. I did, maybe I did get it. I did not read it. I
Okay.
was not aware that I got it. At some point, I'm going to inquire what the grounds for termination are, just if that's.
Well, they're going to talk about that.
Excellent. Thank you, sir.
But before they did, I just wanted to have an understanding of whether or not people read the package and who did or didn't. So, yeah, as Mr.
Mr.
Attorney Dugas
Mr. Weldon,
indicated.
I have a quick question, Mr. Weldon.
Oh,
Did the package include the notice to the teacher?
it did.
I just didn't have a recollection of seeing it, but okay.
So, yeah, Ms. Alter-Dixon or Dr. Raiola, which one of you wants to begin talking about this?
Dr. Raiola, if you want, I can give the overview, and then if there are any questions or details, obviously Dr. Raiola, who is the building administrator for this teacher, can provide additional information. Good evening, everyone. I will first say that Dr. Raiola brought to my attention his concerns about this teacher a few months ago. And he indicated that he was conducting an investigation and he was going to hold a meeting with her. That meeting was held. In sum and substance, we are under the belief that this teacher did in fact act inappropriately and falsified information that contained in the IEPs for at least three students. Not only is this in violation of state and federal laws regarding the IEP process, as you all know, IEPs, the Individualized Education Plan, thank you, are key to students' development and their education. This allows us to provide them with any services or special programs. So upon this investigation, this was done with Dr. Raiola, in addition with our special educational department. They conducted an investigation, they looked at the reports, and then they did actually, Dr. Raiola called in the teacher and interviewed her with her union representation. Upon the conclusion of that meeting, he contacted my office. I informed him that we will take this further by holding a formal disciplinary hearing with Human Resources and her union. That was held. We had, I believe, 2 separate meetings with the teacher and her union. We concluded the first meeting to allow her time to speak more with her union. And after the meetings and follow-up, we did follow up with questioning the special ed department again as well. I believe we had a couple of follow-up questions. It was determined that we did, upon further investigation, additional students' IEPs were called into, came to our attention that they too may appear to have been falsified. At that point, on or about February 10th, 2021, The letter was issued to Ms. Smith, informing her of her possible termination.
Okay, is that it?
That
Mr.
is-
Chair, just to add,
Yes.
there was no dispute that these actions were taken by the teacher. She did not deny them. She actually did affirm that these actions were taken on both occasions, one with Dr. Raiola, and again in the subsequent meeting with Human Resources and myself. We did offer the opportunity to the employee for a separation, a mutual separation, which she did not accept against advice. So that's where we're at today. These are legal documents that have been falsified, and it is concluded that we move forward. This potentially could have opened up liability for the district on a whole nother level.
So to clarify, the subject employee acknowledged doing these things.
Yes, in 2 meetings, one with Dr. Raiola and her union representative, and again, in a meeting with Dr. Raiola, HR, myself, her union president and CEA rep.
Could I
Was
ask a
any-
question, please?
Can I, let me finish. There's a lot
Oh,
of
I'm
hands up.
sorry.
I'll go around.
Okay.
To clarify, did the employee offer any mitigating circumstances as to why?
Other than the fact that there was deadlines to meet, and rather than actually hold the meetings and, as you should, decided this was the best way to meet the deadlines, apparently.
Okay. Do you have anything to add, Dr. Raiola, before we go around the room?
No, that summarizes what's occurred.
Okay. Like I said, there are several hands up. The first one was Mr. Taylor, or is that left over from last time?
No, that's a fresh question, Chairman.
Okay.
Chairman Weldon, and I don't know who to direct this to. Was the teacher's action and falsifying the EEP to the student's benefit or detriment? Because I know sometimes you're on the borderline. If you're a point or two away, you don't get the special help, and maybe the teacher thinks you really need the help. What was the teacher's intent? Was her best interest in the best interest of the student to see that they got the help they needed, or was it solely to cover up a dropping the ball?
So,
Yeah, Dr. Raiola can speak to that.
yeah, so on a yearly basis, all students that are receiving special education are supposed to have an annual review. And every 3 years, they're supposed to have a triannual. The triannual requires a series of testing to determine if they're still eligible for special ed. And the annual review just makes sure that they're making adequate yearly progress towards their different goals. She didn't hold either of those meetings for the different students. So I would say it hurt the students because we didn't sit down as a group to decide whether or not we were educating the student properly, if something needed to be changed. And she represented that she did.
Were there mitigating circumstances involved, Dr. Raiola?
None that I'm aware of. She did offer a rationale of, well, I couldn't get the parents in. And, the procedure is if we're unable to get a parent in place, we still hold the meeting without the parent, and we document all the efforts that we've made to get the parent in, to engage the community, to engage them and do these things. And, we found no evidence of her doing those things.
So she blatantly violated protocol?
Unfortunately, it appears that way, yes.
And is it safe to assume that she's had no rebuttal to this? She's in agreement to the termination?
I have heard no rebuttal that would justify this. I've heard I clicked the wrong button on the computer. I've heard some different things from her, but none of them really flushed out in the end to make any sense as to why we wouldn't follow the protocol that's in place within the district to do these things.
So it's clear that you and the superintendent are both in agreement that termination is the proper cause of action?
Yeah, she definitely violated the student's rights.
No, that was not my question, Dr. Rell. It's your professional opinion and the opinion of the superintendent that termination is the proper venue?
I would say it's something that we should talk about and look at. One of the reasons for termination is moral misconduct and insubordination. And, I don't make this decision on my own. Without a doubt, it brings me no, it's a challenge to sit here and have this dialogue for sure with our teachers. It does not happen often, and it's a concerning thing.
Absolutely, and I appreciate that. But Dr. Aiello, I'd like you to answer my question. You have a PhD. You're an educated individual. The superintendent is the head of the Bridgeport school system. Is it, in your professional opinion as a PhD and a superintendent's opinion, that is the best cause of action to terminate this teacher?
Yes, it is.
Okay, thank you, sir. I appreciate that.
You're welcome.
No further questions.
I just want to clarify, this is not protocol. This is federal law. IDEA is federal legislation to protect the rights of children. So this isn't violating just Board of Ed protocol. This is federal law that has been violated.
Correct.
May I ask a question?
Ms. Allen, yeah.
Was she working within her certification or outside of her certification as to this incident?
Within her certification.
Okay, thank you.
Okay. Mr. Skolovec?
Oh, yes, a couple of questions. If we could take them one at a time. How was the teacher notified? And are we sure she was in receipt of the notification of today's pending action?
Would you like to answer the notification was through, she was notified in a written letter.
And how was the letter
received?
Was the letter received?
She was given the letter via email, and then it was sent by mail, the notice of intent to terminate her. She did receive it because we've had conversations about it through her union regarding our plan to terminate her.
And but tonight's meeting in particular, in case she decided at the last minute she wanted to mount a defense. Does she know this meeting here tonight is taking place, and do we have constructive receipt of any?
Floyd, would you like to answer that one?
Yeah, the only notice that is required to be provided to her is the February 8th letter that was given to her. And when she failed to request a hearing, she essentially waived her rights at that point in time. So there was no specific requirement to notify her of the meeting tonight. She's waived her rights.
Okay, I got a couple other questions about the charges itself. All right, and a basic IEP. Could somebody just run down real quick the process of an IEP, like the review?
Well, the
Would there be people
process,
present?
the initial falsification of documents was writing that there was minutes to a meeting that was never held with attendees that attended a meeting that was never held. That's first and foremost. The development of the IEP is made at that meeting. So anything placed in the IEP is supposed to come out of a meeting that was held, which she never did hold at. So this has layers to it, Mr. Sokolovich.
Right. Yeah, I'm inquiring because in the initial package we received, it stated that fraudulent action was a student was not present, and on the IEP itself, it is checked that the student isn't present, and it also has the first one has Mr. Christopher Johnson, Mr. Brian Schaefer, and Miss Kristen as being present at that meeting. So you're saying none of these people were at that meeting?
There was no meeting for them to be at.
And And you said we found two more instances of
At
this
least.
occurring?
At least.
At least two. And are we just reviewing this teacher's actions, or are we reviewing further all the IEPs conducted at Bassett? Because I would hate to think that this is a systemic problem. Well, not just Bassett, every school, just to make sure it's not a systemic problem that everybody's behind in their paperwork and they're just checking boxes.
Dr. Raiola?
Yeah, I could speak, in conjunction with the Office of Specialized Instruction, we have done some spot checks within the building to ensure this wasn't something a practice that was carrying on within the building. And we found no evidence to support this happening anywhere else except with Ms. Smith.
And last question, what was the initiating factor that started this investigation?
It was actually an internal check. So the Office of Specialized Instruction and us, we have some internal checks to make sure our IEPs stay within compliance. And one of these IEPs was triggered as coming out of compliance. So that triggered a review of the IEP, and we started asking questions as an administrative team and realized that none of us were going to this meeting that Ms. Smith alleged occurred. So that was the initial trigger.
Okay, thank you. That's all for now.
So that was actually one of my questions. So you guys do have a process to kind of self-audit and spot check.
We do, yeah.
Throughout the year.
Yeah, we do. Yeah, Rob Arnold does a great job. He's got some protocols in place with Lauren, and we have some internal stuff at Bassett that we do to make sure we're staying in compliance and these things don't happen.
That's good. That's good. First, Dr. Fabian, and then Mr. Lombard has his hand up.
I put my hand up.
Yes, I would.
Did you too? Okay. Dr. Fabian, go ahead.
Can I go or should I wait?
Nope, go ahead.
Yes, I would like to know a little bit about the history of the teacher and her performance. That's question number one for me. And question number two, where were the supervisors? Like who's her supervisor and what were they doing to ensure that in fact they were doing their job? And then I want to return to the issue of notice, because I saw the letter that was sent. I didn't see anything that suggested to me other than the head of HR, Ms. Dixon, I think, stating that she knows that the letter was received because conversations were had. I want to make sure that, we don't, people are entitled to notice in a hearing. It's a very fundamental concept coming out of Benoyer v. Neff. And I just want to make sure that this lady received adequate notice. So those are the issues that I would like to hear about.
Okay, well, I'm going to jump in and answer that. Number one, I don't think the employment history of the individual is relevant in this situation. That's number one. I think that, we're not going to give her a pass because she's been a good employee till now.
I wasn't suggesting that you did.
No, I know.
Suggesting that I want to know if there are mitigating circumstances, or if we're talking about someone who has been so extraordinary that leads us to think that perhaps, she may have had some mitigating factors that led her to this. I would, if you tell me, can you remind me when were these IEPs supposed to happen? I'm sorry, I just don't have the papers in front of me, and I reviewed them yesterday.
These were from the fall, I believe.
Yeah.
So going back to the second question, I think this is where her supervisors did do their jobs properly and catch the error. This is not something that would happen, I don't think, very often. So the fact that they were on top of it is just a testament to the work that the supervisors and the administration at Bassett is making sure that, these matters are handled properly and meetings are being held and IEPs are authenticated. And I think you had one last question, Dr. Fabian, I don't recall. The last.
Yes.
Yes, I got it. Yes, after the notice, there was discussions with HR and the collective bargaining unit on how to possibly settle the termination rather than it get to this point. So we did try to come to an agreement. Again, as I mentioned, it was not accepted by the employee.
There was also an email sent, so she got it via email.
Let me return to the supervision issue. She writes these IEPs. Who reviews them? Who does she submit them to?
A copy goes.
I have to tell you, I'm not Mr. Testani, I heard your answer. And I have to tell you, I'm not 100% persuaded by your answer. I am in no way, shape, or form looking to provide an excuse for this teacher that she has not provided herself. But, if, there is supervisory responsibility here, someone should have been paying attention, and we're putting it all on the teacher. So we might as well be honest. We might as well put it on the table. And I would like to hear what is the process, and why didn't the supervisor, upon submission of these IEPs, realize that these IEPs did not happen until, some time had passed?
Well, the administration is there in terms of supervising the teacher more than an instructional component. The IEP, once it's finalized, a copy is sent to the parent, and a copy is sent to all the teachers who have to implement the IEP within the classroom. So there may be a delay in finalizing the IEP and it actually being implemented. It's not a long delay, but it does take a little bit of time.
Let me ask you, is the IEP submitted to the principal?
No.
Who is the IEP submitted to?
It goes to the case manager, which would be the teacher in this case, and the other teachers that service the child and have to implement it in the classroom.
And would those teachers have had an opportunity, or would they have been expected to have been part of the meeting in order to develop the IEP?
Yes, at least one.
So they received an IEP asserting that they were present, and they sat on it?
No, that's what we're trying to say. It was discovered that this was falsified. There wasn't much time that went by from it actually happening till it was discovered.
Well, what's that period of time?
I don't have to look up the IEP here. The date on the meeting was in the packet, but it says that the meeting was held on 12/14, which means we discovered it, or the school discovered it, with the Christmas break and everything included, a couple of weeks later. So it was immediately discovered.
Okay, that answers my question. Thank you.
Okay. Mr. Lombard and then Mr. Taylor.
Thank you. So I'm curious to understand, you talked about separation was put on the table, mutual separation, but it was not accepted. I want to understand that, given that she acknowledged she did these things and that these are federal laws and she broke them, and that there is no excuse provided other than pressing the wrong button. What was her rebuttal to why the terms of the separation, as opposed to going to this point where we are now, were not good? What was going on there? What was her argument, her reason?
There was no reason. She just requested that we pay her till the end of the school year and she would resign. We did not think that was appropriate.
She also wanted this removed from her employee file, and that we not disclose any of this.
So the end of the school year, would she still be actively working, or just being paid and not working?
Paid not to work.
So she'd want to be paid not to work, and then she would separate. The mutual separation agreement had to include her not working for a semester, being paid, and this not showing up on the file.
On her end, correct.
On on her end. So she would have been okay with that kind of a separation. So she
Correct.
understood that there was a call for separation. Right? She
Correct.
didn't think she had a cause to stay on. So that was
Correct.
my first question. My other question is, Attorney Dugas mentioned that since this did not go to an independent review, and then it then came directly to the superintendent, that you were in the position that you could have made this decision yourself. Did I understand that correctly, Attorney Dugas?
That, I said that was one interpretation of the statute and the law. Another is that it still has to come before you to approve, and I've recommended to the superintendent that we take that step.
So it could have gone either way, but that was your recommendation that we take that step.
Yes, sir.
Okay, and I'm thinking of this because, you know, like Mr. Taylor asked the question, is your professional opinion to Dr. Raiola that given everything and given the laws that termination should happen, and he ultimately said yes. It seems to me that that's also your opinion. I was just wondering why it came to us at all, really, is why I was asking. But I understand the attorney thought that would be the better course of action to bring it to us so that we make that decision. So I just want to understand why we were meeting today. But I think I understand it's to cover all bases. So those are my two questions. Thank you.
Mr. Taylor?
Yes, Chairman Weldon. What subject does the teacher teach?
Special education.
Special ed. How long has she been employed with the Bridgeport Board of Education?
I don't recall offhand. Denise may have that information. But, I want to say close to 10 years.
So she's a 10-year employee with the Bridgeport Board of Education. Has she had any disciplinary actions in her employment record in the past?
I'm not privy to that.
I have a copy of her personnel file. I just took a brief look. I note that there are a number.
Excuse me, Mr. Dugas. Excuse me, Attorney Dugas. He's the superintendent of schools. He wants to terminate. He doesn't know what her employee file looks like. We have to confer with you. I'm not okay with that. Gentlemen, I'm not okay with that. The question was directed to the superintendent of the Bridgeport Public School System. We have a 10-year special ed employee that's been with us 10 years, and the superintendent can't tell me that she has any misconduct in her record in the last 10 years, and we are in dire need of special education teachers. Gentlemen, I'm not happy camper right now. So continue, Mr. Dugas. I apologize.
I just was going to note that in my quick review of the file previously, I noted multiple correspondence regarding poor attendance.
That's it, poor attendance.
That's the only thing I happened to notice when I was flipping through briefly.
Okay, so let me just recapture the facts here. We have a 10-year veteran of the Bridgeport Public School System that teaches special ed, and the only thing in her file is some absentees. And then we fast forward to this, a falsification of some, I believe, IEPs.
If I may, Mr. Taylor, there's also correspondence about not submitting lesson plans or adequate lesson plans.
At what time frame were the inadequate lesson plans?
This happens to be a memo from 2013.
Okay. Was she written up or any?
It was a reprimand, yeah.
Reprimand. So does she have a reprimand for her tardiness or missing the days?
I believe that's what I saw. Let me just check quickly.
I think Yankees at the window.
Yeah, written reprimands for poor attendance.
So there's 2 written reprimands, so I'm clear, for poor attendance and failing to provide lesson plans?
I believe there are more. I'm just flipping through the file.
Mr. Taylor, if
Yes.
I may chime in for a second, this is my 3rd year now at Bassick. At the end of my 1st year, we did make a recommendation to have Ms. Smith on structured support. due to some concerns around instruction and her instructional practices. With COVID last year, I'm not sure exactly if she ended up off of structured support, but that's that's a kind of a probationary level of evaluation. So, during my time there, we have had some performance concerns that we were trying to support her with instructionally. But this is just the egregiousness of this for our students is what is really provoking our actions and me bringing this forward the way I am with Miss Altro Dixon and ultimately the superintendent to you guys.
Oh, Dr. Raiola, I'm not taking any emphasis out of the conduct, but I'm a man of forgiveness. And, if somebody's been a loyal, dedicated employee and they had a bad sense of judgment, I'm not in for,
Understood.
If there's a reasonable measure of disciplinary action that could have been had, aside from termination, putting someone out of work that is a special ed teacher that I believe is a desired commodity right now, especially for us with 10 years past. I mean, it came to the board. I have a hard time getting to the point of termination. I'll be honest with you. Maybe my colleagues feel different. Listen, things happen. I realize it's wrong. It appears that she owned it. She accepted it. Listen, I've made poor judgment calls in my life. And I mean, people want to persecute people. I am unfortunately I don't subscribe to that theory. So if she owned it and she was responsible for it and there's a way she accepted it, I don't think I'm going to be supporting termination. I apologize. I really don't have any more questions. That pretty much put a light on it for me. So I'm sorry for taking up so much time.
Mr. Chair, I just want to say to Mr. Taylor, she did not own it. She admitted it, and in 2 separate meetings tried to blame the administration for her actions. First, Dr. Raiola, by saying that he went to her and said, you need to get this done. And her interpretation of getting her work done was to lie. And then she, in a second meeting, tried to blame the assistant principal because he went to her and said, you need to get these PPTs done. So she did not own her actions. She tried to put the blame on others, just to be clear.
I respectfully disagree with what you just stated. If she said that she did it, that means she owned it in my book. Her saying, hey, here's why I did it, because I felt pressure from the principal and the other person you mentioned. Listen, is it casting blame? Absolutely. But she didn't lie and say I didn't do it and waste your time and Dr. Raiola's time making you prove her a liar. She owned it. It's human nature to cast blame, to take the light off themselves. That's
Mr. Weldon, can I speak?
Yeah, Ms. Altro Dixon.
Thank you. Mr. Taylor, technically, she admitted originally that she did it. Then she tried to backpedal and said, no, I didn't do it. It was a matter of pressing the A button versus the S button on the keyboard. That's what she said about these reports being finalized. But that being said, whether or not she owned it or she didn't, at the end of the day, she has violated federal and state rules. In addition to that, by her falsifying the IEPs for 3 of our students, she has impacted their education, not just this year, but going forward for their entire educational career. This is not something that can be erased because she owned up on it.
Well,
owned it. This is huge. This is not someone falsifying a time card. She has deprived students of an education and services that they are more than likely in need of because she failed to properly do her job.
Listen, I'm not making excuses for her at all. I just taking into consideration, I'm only privileged to hear one side of the story, and that is from the Board of Education side. I'm a free thinker. I'm not quick to judge. I don't believe everything I hear, and I don't believe everything I see. I like to gather information. It was brought to me as a board member. I'm one of 9. If this was a simple decision, the superintendent had the authority to do so without coming to this board. Once you came to this board, I am one of the 9 members. I will do my due diligence to see if this measures up to what I feel termination. Listen, she may have violated federal law. We have a mayor that violated the federal law and is mayor again. I don't know if she hindered the student or she didn't. I'm not qualified to make that decision. What I'm trying to do is gather facts that we have a 10-year special ed employee that made a mistake, did something that is illegal. If that's the case, maybe you should alert the federal authorities, because the superintendent, I don't believe, has the power of arrest for a federal arrest. So as a board member, I'm getting to the point where I wanted to see if termination, I can live with that after this meeting, or if there was some type of punishment or reprimand that would suffice. If the woman was under pressure, pardon me, or the teacher was under pressure, do we turn on our own that quickly? That's all. It's not, I'm not casting stones at you. I'm not casting stones at her. I just want to make a prudent decision, because this is going to affect a lot of lives. And if it was a simple decision, it would have been made by the superintendent and not brought to the 9 of us. I don't know how my colleagues feel about it, but that's just my position. And I have the utmost respect for you, but please understand my position as a human being, as well as an elected official.
Attorney Dugas, you have your hand up.
Yes, I just wanted to note, I also noticed in the file, in the past, she was also on a plan of improvement. And in my experience in representing school districts for 35 years, it's extraordinary for some, well, it's very unusual for a teacher to be on an improvement plan twice, particularly somebody who's put on a plan this late in their career. And that suggests that she is probably not among your top performers.
Okay, there's several hands back up. I think the first one was Mr. Lombard. You're muted.
Thank you. I'm losing my connection, so I don't know if you could. Can you hear
Yes.
me?
I hear you.
I think you should pass over me. I have a bad connection.
All right, Mr. Skolovic.
Yes, I'm a little confused. I think I may be mistaken, but I heard two different answers to the same question. When I asked what was the initiating thing that made you go look at the IEPs, I was told it was a routine check, and it came up. And Dr. Fabian asked about teachers and other teachers being notified and having their name on the information. The answer was, that's how we found out. What was the initiating thing? Because if teachers receive these and they receive these students and their names on these things, they should be reporting, hey, my name's on this paper. I was in the meeting, and it should be found out immediately. Not 2 weeks later, not 3 weeks later, not a month later. And going back 3 years, you got teachers on these things with the IEP, the students where they're implementing the IEPs that are on these pieces of paper, were in these meetings, and or were not in these meetings, and just accepting the paper with their name on it as if they attended. Now, I don't know what the case is, but I'd have to agree with Mr. Taylor. But my only issue with this is that the teacher is not here to defend themselves. The way this case is presented and the evidence, and we only got 2 cases of the 3 in our package. We don't have the 3rd case. And if she would mount any kind of defense, I would tend to be leaning towards throwing it out, because this case is badly presented. We don't even have the personnel file to make a judgment in this thing. I mean, that should be standard practice. You look at terminate somebody, you have prior instances, and you build a case slowly. I mean, I've been in arbitration myself for my own malfeasances, and I've beaten cases because I came and spoke up and they did not have their cases prepared. I tend to agree with Mr. Taylor. I would look for a penalty lower than termination, and possibly even going with the resignation at the end of the year, because if any of this is true, this person probably should not be with us. But termination, I think, is a bit too harsh for the way this case was prepared. Thank you.
The way I interpreted it was that Mr. Arnold conducted his usual review, and then other things occurred subsequently that made Dr. Raiola realize this was not an isolated incident. So I interpreted it to, Mr. Arnold discovered this first instance, and then, like these teachers said, hey, or people who were alleged to have been in these IEP meetings were made aware of that, and they said, no, I was not. And that's what made Dr. Raiola see that it was not an isolated incident. That's how I interpreted it.
Can I just
Maybe I'm
clarify? I answered the question. I said the question was who attended, who was in the meetings and all. What I said was that they would have gotten a copy of it at some point, and they would have noticed that they were named on a meeting that didn't exist. It was caught before that. The meeting is held. The IEP is discussed. The teacher, the case manager, then goes back. They have time to rewrite everything because it's you don't formalize it right there at the meeting. You take notes, you take minutes. All that is translated into the document. That document is then sent to the parent. The parent reviews it to make sure that it's accurate. It's everything that was discussed. And then it needs to be signed off on. So it was in that process, it was discovered because it was finalized and reviewed. That, in terms of the personnel file, I'm going to go back to my original, the employees not being terminated because of a case that was built over time because of poor performance. This action could be referred to the State Department of Education, and the certification office could pull certification. It is that serious. That's why 10 years of anything is not relevant when it comes to this egregious act. But again, on Attorney Dugas's recommendation, I brought it to the board. Not the first person. I would have had no problem doing it on my own. I believe strongly that we cannot allow our district to be lax on things like this. This wouldn't fly in Westport. This wouldn't fly in Trumbull. It wouldn't fly in any other suburban town. Why would we allow this to happen here in Bridgeport? It boggles my mind that we're even having this discussion, with all due respect.
Mr. Lombard, your hand is back up. Yeah, I see you, but
Yes, okay, thanks. I'm having.
Everybody's got their hand
up. Sorry. So I was thinking, and then Mr. Taylor said it. So given this particular infraction, and then the way our district handles these federal state infractions, were there other alternatives that could have been done, other disciplinary actions that could have or could still be done? I know the discussion of separation was there, so that wasn't going to be termination. So termination wasn't the mandatory reaction, but there was something else. What other possible things could have or could be done?
I mean, we could suspend her with pay, which again is a reward. We could just refer it to the State Department of Ed. If they pull her license, she would never work again in any district, which could possibly be the case. But I mean, you want to try to settle it in terms of letting her get suspended without pay and then return back to the classroom?
No, the reason I'm asking is I'm wondering if our hand is held, if when this particular type of infraction occurs, if the response is black and white, there is no remediation, there is no working on it. It's just that's it. Obviously there are certain things that happen, that happen between teachers and students sometimes that you're just like that's it. So if that's not the case, what is the reason why we would pursue this as opposed to any other possible alternative disciplinary action?
May I answer that?
Yeah.
Who's that speaking?
This is Floyd Dugas. I'm sorry. Certainly, you can always issue lesser discipline, but again, my opinion, if you want it, is that this is among the most serious infractions I can imagine a teacher creating, short of the types of things that we worry the most about in terms of interactions with kids. This is, I mean, I don't know that I've ever seen this in my career. It's falsification of federal and state documents. It is denying the student their rights under the law. And frankly, they have created a huge potential liability for, she's created a huge potential liability for the district under the special education laws. It's serious. It's very serious.
Thank you.
Okay, Mr. Benahan, and then Dr. Fabian.
Thank you, Mr. Chair. Good evening, everyone. And I believe, I don't know, Mr. Florio, Mr. Destani, or Ms. Denise, thank you, asked me this question. But before that, I will agree termination of her or any teacher that blunts in lies or illegal documents or the service of those children or Bridgeport school. But I have some question before any, we keep forward. And my question is one, what was the case law? How many students in our school are in the same position of IEP negligence? How many teachers were also involved with the student IEP? Who's responsible for keeping the anniversary date of IEP for meeting? And my last question is reprimanded for lesson plan, and no one checked on her doing work on IEP meetings. I don't know, Mr. Floyd, Mr. Steiner, or Ms. Denise can ask me that question, please.
Okay.
I don't mind chiming in.
He read off a list of questions that I think maybe would have been hard to just digest. Do you want to just do them one by one?
I know the first one I heard, the only one that I think I can answer is the question about something about case law or citations. I research, I'm involved in multiple teacher terminations a year. Every time we research the case law, and in all honesty, I have never seen a case, nor am I aware of one. And as you know, you probably know, we work with about 19 or 20 school districts, actually closer to 30 school districts. I've never heard of anybody doing this. So there's certainly no specific case law, but on the scheme of things of what people do, as I said, this is very much one of the most serious infractions I've ever seen.
Thank you, Mr. Floyd. So my second question is, how many students in our school are in the same position of an IEP neglect?
I'm not aware of any. This doesn't happen very often, but for a reason, because people understand when you're formulating an IEP for a student, that it's a legal document, and there's.
Can I, hang on. If you're not talking, please mute.
So, I would, our staff is professional. Our staff is exceptional. This happens to be someone who, again, poor judgment, as Mr. Taylor said, but it does leave the school district open to huge liability down the road if this was not caught. I mean, just, I don't know how much else to emphasize that.
Thank you, Mr. Sitani. And the third question is, how many teachers were also involved with the student IEP?
Well, this was the case manager. The student has 4 teachers that is currently in the semester courses that teach that student. So I'm not sure who was, well, no one was at the meeting. So one of them would have had to be represented at that meeting to provide input at the meeting as part of the PPT process.
Thank you, Mr. Testani. The fourth one is, who is responsible for keeping the anniversary day for the IEP for the meeting?
Case manager is responsible.
And the last one, reprimanded for lesson plan and no one checked on her doing work in IEP meeting?
You want to observe the instruction in the classroom. The other stuff is just administrative paperwork. That's not, when you're evaluating a teacher, it's their classroom practice, their instructional practice, not the way they complete their paperwork. I mean, you want them to be able to do a good job with paperwork, but more importantly, you want to make sure that they're providing proper instruction and support of the students they serve.
Thank you, Mr. Testani. No more question, Mr. Chair. Thank you.
You're welcome.
Okay, Dr. Fabian, your hand is up.
Thank you. Yes, I'm having a little bit of a challenge here because clearly I am only hearing, let's go with the word, the administration side of the story. So I would like to ask whether procedurally, whether we can extend an invitation to the person who's likely to be aggrieved here, the teacher, to come before the board so that we can hear her version or his version of the story. So that's question number one. Is that a possibility?
Who wants to field that?
You're on mute, Floyd.
I think, yeah,
Sure, do
why
this.
don't I respond and then I'll let the superintendent or anybody else weigh in. She had the right to be involved in a process. And that right was by filing a request for a hearing within 10 days of February 8th. She failed to do that. So she has effectively waived her right to participate in this process. So I think the appropriate thing is to just move forward with the decision. Is that something you could do? I suppose in theory, but my advice would be to make a decision up or down.
She was
right.
well represented, Dr. Fabian, by her union president and also the CEA attorney. So she was well aware of the rights that she had in this process, and again, waived those rights by not acting.
Well, you're asking us to make a decision, and in part of making that decision, I have to be comfortable that I am both being equitable to the teacher and equitable to the district. And I feel like you're putting us, the board, in a position of hearing one version of the story with, even within that version, I can already detect some inconsistencies. And yet you're asking me to sanction a very serious and significant step. I think that, without hearing the other side, the adversarial system exists because it helps the truth percolate up. So I very much hear the advice of counsel here, but I have to respectfully decline it because it's not about the right of the teacher and what she chose. It's about making an informed decision that is reached with adequate information and with equity in mind. And I am unable to do that, having heard one version of events with internal inconsistencies. And that's why I was asking whether it would be, whether it would be possible to extend her the invitation. If she doesn't take the invitation, guess what? I'm all over it. I wholeheartedly agree she should be terminated. I just want to make sure that I make that decision with the information I need.
Okay, I understand that. The reason why she's not here or she didn't come before the board is because she chose not to. That's why you're only hearing our perspective on this. But I will disagree with you on the record. There is no inconsistency in the story. That's very clear that we follow the letter of the law here, or we wouldn't be here.
What standard should I use in making this decision? Let me ask the attorney. In making this decision, what standard should I use? How should I weigh the evidence presented to us, both in the file and through this discourse?
This is not a full-blown evidentiary hearing. She waived her right to that. And I would simply say, if you believe and support the superintendent's recommendation, you ought to approve it.
If I can add to this, as the head of HR, I have a duty and responsibility also to conduct an investigation. I am a lawyer by training. I know how to conduct investigations. I know how to conduct hearings and things like that. I also know about rules of evidence and standards of proof. When I conduct an investigation, as I did in this situation, first and foremost, I rely on Dr. Raiola, who alerts me to his concerns, to first do his part of the deal or the process in meeting with this teacher, gathering his documents, and taking the first step of holding the meeting and giving her a chance to offer any type of explanation, defense, or whatever regarding what he discovered. She did not she was given that chance, and during which she admitted to Dr. Raiola that she had the meetings. She didn't have the meetings, but she did note that she did do it, that they were held, but they weren't held. The next step then, when Dr. Raiola produced his report to me, which you were all given, he indicated what happened. Based on his initial report, I deemed it appropriate to take this to disciplinary matters and hold my own meeting, my own investigation. That included meeting with her union, Dr. Raiola, and again, she was given a chance to explain how this IEP appeared to be falsified. Meetings were held, but they weren't held. She failed to give any type of adequate explanation. She literally said, it is merely a matter of accidentally pushing the A button versus the S button on the keyboard to finalize a report. That is not true. So then she says her piece. I follow up with questions. Dr. Raiola may follow up with questions. Her union follows up with questions. They asked to have another meeting to break so they could talk. We came back a few days later. In the meantime, I followed up as the investigator on things that were said. It was during that time where we discovered that there may be additional IEPs that were falsified. Because of this, we went back. Dr. Raiola and the special ed department went back. I followed up and talked with other people who were at Dr. Raiola's meeting with her. And they confirmed what she said to Dr. Raiola, which during my meeting, she tried to backpedal on. When we met again, she still had nothing to prove that she did anything, that she was right in what she did. She completed 3 IEPs, falsely completed them. These IEPs are used to how to determine to best service students. Students with IEPs are not our scholars. These are vulnerable students. They are in need of these services that these IEPs determine. That is how Dr. Raiola, the special ed department, the speech pathologist department, the social worker, everyone determines what is needed for these students. Her actions, deliberate actions, because my investigation concluded that her actions were deliberate. She falsified these because she just wanted to get these reports done because she was running out of time, and this was easy for her to do. Her actions have impacted at least these 3 students in a negative way. Her deliberate actions have opened up our district to liability of lawsuits by these parents. This is not something we take lightly. I don't take lightly to having to terminate someone or recommend termination because I understand we are talking about someone's livelihood. But I work for the Board of Education. I work for the children of Bridgeport, and my job is to ensure that I get them the best quality staff in there, and I address those who fall far below the adequate line of performance, which she did. So my investigation and my decision and recommendation to terminate her, my recommendation to the superintendent was not done lightly, was not done half-heartedly. I investigated it. I followed up. We gave her every chance we could for her to produce anything to refute the charges and the facts presented. She failed to do so. She failed to take the basic steps of filing a request to have a hearing regarding this. To simply say, let's keep her on payroll until the end of the year and let her resign, we're sweeping it under the rug. Then she's going to go to another district and do this again in another district. I'm asking the board to take a stand here. Take a stand on behalf of the students in Bridgeport and a stand on behalf of any other student if she goes to any other district. This is not, I understand it's not an easy decision. And it wasn't an easy decision for me to come to. Thank you.
Anything else, Dr. Fabian?
No, I just want to highlight that I understand the due diligence that has been done here. But when you ask me as a board member to make a decision, I want to make an informed decision. And I am articulating as clearly as I can that absent having heard directly from the teacher, I am hearing one version of events, which in my opinion, I repeat again, in contradiction of what the superintendent said, it is my view that there has already been some inconsistencies. And I have concerns over the supervision of this teacher. And I want to make sure that if we're going to mince discipline, that discipline not only goes to the teacher, but to those who were also responsible for her supervision. Someone should have been paying attention to what she was doing. So we want to fire the teacher, let's fire the teacher, but let's hold the supervisors accountable as well, up the chain of command.
I have to interject here. The supervisor did their job, or we wouldn't be here.
Well, if the supervisor did their job, I wholeheartedly agree that we wouldn't be here. There would have been some mechanism in place to recognize that this teacher was falling behind. There would have been some mechanism in place to recognize that this teacher was struggling. You know, this is all happening during a pandemic. May we not forget. Let me ask Ms. Alto Dixon, because this might actually put it in context for me. Since you had the opportunity to interview this lady, did you see this lady? Did you see any signs in her that caused you to believe that there was something going on that could have impacted her mental health? Because I am trying to understand here a little bit about how this teacher went about doing this. Like, I don't see any rational reason for her to do this.
May I caution about getting into any discussion about anybody's mental health, please?
I wasn't going to. I'm not a medical professional, but if she wasn't on a support program, as Dr. Rayola had mentioned, if she didn't have that in there, and her demeanor during this meeting, my meetings with her, was one of blasé. At first she was just like, oh, well, I mean, it was just like I said, and I know I keep saying that statement, but I mean, I was flabbergasted when she said that she equated finalizing an IEP as simple as accidentally pressing A on the keyboard versus S on the keyboard. I sense that she did it because she knew she had a deadline. She knew it was going to be more work because of the pandemic. It is a lot harder to get people in and everything like that. And she saw an easy way to get out. That perhaps, and I can't speculate, but from what I gather from what she said, she saw this as a chance to just get the work done. With everything going on, perhaps it won't be noticed.
I have no further questions. Thank you.
Okay. Mr. Sokolovic, you have your hand up.
Yes. I'm a little confused. Since I got the notice of this meeting, I've have serious confusion about why we are not in executive session. I want to always vote for open meetings, and the only exception I usually make is a real estate deal or a personnel issue. Now, we're being told over and over again, we're liable to lawsuits because of this, and we're airing it in open forum rather than an executive session. Why hasn't the attorney suggested we do this in executive session? Hey, you're liable to possibly $1 million lawsuits. This is not something that should be vetted in an open forum. There's something seriously awry with this whole procedure, and I can't put my finger on it, but I've never seen somebody suggest let's do something in public session with employee discipline. Why are we in public session right now? Why wasn't it suggested to do an executive session?
Attorney Dugas?
And I may add, I may add that I email expressing my concerns about being in a public session.
You did. And the attorney is here and he'll explain.
Sure. I mean, very simply, you don't have to go into executive session. This was a recommendation by the superintendent where an employee was subjected to an investigation and an opportunity to present their story. Did not provide an adequate explanation, and then was given a right to have a hearing. And they waived the right. Frankly, I'm not suggesting this isn't a tough decision for you guys, but this should have been essentially a pro forma. Superintendent recommended, she had the right to a hearing, she neglected to take the hearing, and then you would vote on his recommendation without having to get into even the level of detail we've gotten into here. So it wasn't noticed as an executive session. Obviously, we cannot go into executive session now once the meeting started because there's certain procedures you have to follow, and that wasn't anticipated. So that's the best answer I can give you.
And another question. It would be a relatively easy decision had I had maybe one more piece of information. Perhaps one of the teachers saying, I was not present at this meeting, somebody said I was at. Another piece of information that would be helpful is maybe the director of personnel's interview notes or something, instead of just hearing auditory testimony. I mean, we're hearing defense secondhand from the meeting. I mean, but if we had anything in writing, what she said, and we could have seen this and evaluated this information beforehand rather than just getting it a piece at a time. In the future, when seeking termination for personally my vote, I would like more evidence. I mean, we're talking about falsifying a federal document, which is possibly a crime, taking away somebody's certification, and we're doing it on basically say so. And I would definitely be more comfortable with more documentation, because so far all I got is a stack of paper. Thank you.
So more like a written summary with the packet as the backup, but a written summary as a cover.
Right, and that's what I'm accustomed to in these hearings is letters, 3 or 4 letters back and forth to the teacher to improve your performance. And this is I'm not saying that this teacher shouldn't even be terminated. I'm just saying the case is poorly presented for termination, and there's not enough meat in this case for me to even vote for that.
Okay. Your hand up from last time, Dr. Fabian?
No, I just want to, I just cannot help but to respond to the attorney. Listen, I take my role in this board very seriously. There's nothing here that is pro forma. I'm not in the business of rubber stamping anything that comes before me. So I took umbrage to that comment, and I wanted him to know it.
Okay. Mr. Lombard?
I actually was going to comment on a very similar thing, Dr. Fabian. That goes back to why I brought up the point that this could have been done by the superintendent without us. And the fact that it was seen that it was better to bring it to us, I don't want to be rubber stamping something just because. If it needed to come to us, it needed to have a full, wait a minute. It needed to have a full discussion. And that's what's happening now. And it's understandable that there's a desire for different types of questions to be answered and different information to be shared. And that's kind of the feeling I feel like, and I'm going to try to say this politely, I feel like the board was discounted, saying, let's just put it in front of them so they take the blame, or not the blame, they take the ownership of the decision. They'll just rubber stamp this. That's how it feels to me. Now, we may still decide to vote for termination. I don't know where it's going to go, but that's just the feeling I have about this. And I wanted to share that. Thank you, Mr. Chair.
Okay. Taylor? You're on mute.
Oh, sorry, Chairman Weldon.
Okay.
And this is after hearing Attorney Dixon speak. I don't know if this is directed at her, But she said the student was impacted, and then she said she's an attorney. Is she an educator or an attorney or both?
I'm a licensed attorney in New York.
Right, so you're not an educator, so why are you making statements about how the IEP impacted the student?
I'm just going to interject. I don't think Miss Altro Dixon's the one here that is in
I
question.
heard it out of her mouth, Superintendent Testani. That is what she said. I took notes. I wrote it down for my next line of questioning. She stated that the IEP was detrimental. It opened us up to liability. IEP was falsified. She led me to believe that she held the credentials that you and Dr. Raiola hold, and then went on to say she's an attorney. So she's not an educator. Are we in agreement on that?
Correct.
Okay. So, Attorney Dixon, when did you do the student's IEP to determine that he was impacted because she didn't do the IEP?
Mr. Taylor, do you want?
Pardon me?
You're muted, Ms. Dixon.
No, she cut out. Oh, yeah, she is.
Sorry. An IEP is the individualized education plan for students. For students who require special additional services, perhaps speech and things like that. When an IEP is done incorrectly or not done at all, that has an impact on a student's education. Mr. Taylor, you will let me finish, please.
I'm the elected official here. I'm the elected official. Thank you. You're at my Board of Education meeting with my 8 colleagues. My question was, when did you do the IEP? When you say she didn't do the IEP and it was so detrimental to the student, as you said, did you have an emergency IEP the following day to get the student the help they needed? Yes or no?
Which part do you want me to yes or no? I did not do an IEP.
Answer that question.
Yeah. Mr. Taylor, we have, I would have to confirm with a couple of the other administrators, but I know we are in the process or we have completed rectifying the issues with these IEPs within our building and making it right by the kids and by the community.
Okay, Dr. Raiola, then, how far off was the IEP that you are doing from what a subject teacher submitted? Is this whole point moot because they're going to come out the same, is what I'm trying to get at?
I don't know. I haven't reviewed and compared the service grid from last year's to this year's.
All right,
so I wouldn't be able to answer that now.
We have Attorney Dixon saying on public interview that this teacher's impacted the child and we're open to $1 million liabilities and we don't even know if the IEPs are different. If the IEPs are exactly the same, wouldn't the point be moot, sir?
I still, in a certain regard, yes, in another regard, no, because you're still legally responsible to hold the PPT yearly for the kid, for the student, and meet with the family. So, there's, for some reason, I think we're getting lost in some of the issues. And
oh, I'm not lost, sir. I'm not lost. I'm not lost. I heard everything Attorney Dixon said about liability and the IEP, and this student, she made such an issue out of it. This student still doesn't have their IEP. I'm a little concerned now about the Bridgeport Board of Education worrying about its students. As Attorney Dixon emphasized in this public meeting that, oh my God. So I want to know, before I terminate anybody, is the IEP been done by somebody competent, and is it the same? What were the results of the IEP versus the teacher submitted versus the IEP that you guys did after she submitted it? That is the determining question right now for me. So I'm not upset with you. I'm not upset with Attorney Dixon, but there's something not right here. My hair on the back of my neck is standing up. Listen, I'd like to table this or get a motion out there to hear Dr. Fabian, if I'm not pronouncing it, I apologize, and Joe Sokolovic. I think the three of us are all on the same page. I'm not ready to take an action on this tonight. I don't know how my colleagues feel. I don't have the parliamentary procedure to make a motion to either table this and get the teacher in here or further review. But I will tell you, I am not happy what came out of Attorney Dixon's mouth, representing to sound like an educator when they're an attorney. And I issue no discredit, but to say publicly that this teacher has caused this student harm and 3 other students harm when that has not been established is absolutely unprofessional. And I hope the superintendent does something about that in the same manner that he's taking this issue up with this teacher, because I'm upset with it. And I hope my other 8 colleagues are paying attention to what Ms. Dixon, Attorney Dixon, said, representing as an educator working for the Bridgeport Board of Education, that these students are harmed publicly in a public meeting.
Mr. Benahan?
I'm here, I'm listening.
Okay, Mr. Benahan?
Thank you, Mr. Chair. I'm just listening to everyone, and I agree with what Mr. Christopher Taylor said. And one of the things I want to go back to Denise, when you say about non-board members, you have to understand what this person, that Ms. Smith, is doing and stuff like that. You got to make an action. You have to understand. You have to understand, Ms. Denise, that we are non-board members, and we trying to do the best we can. Listen, what happened in this situation. That I believe this meeting, they don't supposed to be public, had to be like a more private. And like Ms. Joseph said, why the teacher's not here, but we make it public. I prefer to have the teacher here, and we can hear both sides. And I'm agreed 100%. And I said, like I said at the beginning, if for some teacher they do something wrong and they break the policy the way it is, okay, let's be terminate the way it is. But we need to bring stuff in the table, more proof. And I agree with what Mr. Taylor said. I agree with what Mr. Fabian said. I agree with what Mr. Joseph said. Let's table this and bring more information and trying to have the teacher here, face to face. Because we bring this meeting public now, so let's bring it to the teacher so we can discuss the situation. If she did it wrong and we know we got the proof, okay, she will terminate, she will be fired. But then any more proof of this situation now is in more public. Thank you, Mr. Chair. No more questions, no more comments.
Mr. Sokolovic?
Yeah, Mr. Chair, hearing my fellow board members speak, I think this would be an appropriate time to raise a motion to postpone for a period of 2 weeks and have a certified letter sent to the teacher and the receipt or that it was
Hang
received
on,
by the
before we
teacher.
start doing motions, okay, I've been very quiet on this. It's typically my process to let everybody else talk rather than myself.
I'm sorry, I apologize.
We haven't even heard from Ms. Allen. Or Ms. Brown. I feel like we're getting kind of lost in the weeds as to whether or not this teacher's past performance rises to termination or not, whether or not she deserves it. To me, deserves got nothing to do with it. An employee broke the law in the course of doing their job. They broke the federal law in the course of doing their job. That's it. They admitted to it. Whether they owned it or not, or deflected it or not, I don't think it matters. They broke the law while they were doing their job, and it's a pretty significant one. And it's
That hasn't
one
been
that,
adjudicated.
can I finish? I let everybody else talk. but
Sorry, my mistake. Sorry, I thought it was muted.
It's really that black and white. Somebody broke the law in the course of doing their job, and the kind of thing they did subjects us to potential litigation. It could subject us to investigation by the state education department and potential loss of funding. When things this egregious happen, your funding sources will do something that's called decline to participate. They'll just put a hold. Or they'll come in and put in an oversight board. If the district isn't capable of making its own decisions about these kinds of things. I appreciate that people want to hear the teacher's side of the story, but she was given every opportunity to state her case, and all she did was admit it, point fingers, and then she waived the rest of the process. She basically withdrew herself. We've spent a lot of time talking about this and talking about what we should do relative to this employee as a person and sympathizing about this employee's plight if they lose their job. But did the employee think about what might happen to the 3 students if this thing happened and nobody ever caught it? I think, you know, this is about as egregious, short of improper contact with a student, that you can get. It's fraud, and the laws were broken. And to me, it's just that black and white. You know, if I was caught falsifying a legal document, I'd be walked out the door that same day. The fact that the statute allows for a process to bring it to the board shouldn't change that fact. Fraud is grounds for termination.
Mr. Chair,
That's just my own take on all of this.
Mr. Chair, before you guys go and make a motion, I just want to go on record to say I had a responsibility here. I'm not going to jeopardize my job, my certification, nor Dr. Rayola's. We have an obligation to report this, to take action on it.
Has this been reported anywhere?
No.
To any entity?
Well, this is the process we're taking. We've discussed possibly reporting it to the state certification board, and allow them to make their decision. But again, this is a responsibility to children and families that myself and Dr. Rayola, the special education department, and our HR department takes very seriously. I apologize if there is not to the satisfaction of the board, but you have a team of people here, all of impeccable records, saying the same thing. And I feel that some folks, including myself, have been discounted tonight. You guys can make or not take action on this tonight. I'm going to stand by the recommendation of termination. I will consult with Attorney Dugas from this point on to see if the board does not take action, what action I can take. Because if this gets reported to the state, the one ultimately responsible and certifications will be on the line and jobs will be myself and Dr. Rayola.
Okay. Ms. Brown, you haven't had your hand up, but you're the only one who hasn't said anything. Do you have anything to add?
Honestly, I've really been just listening to the whole entire process. I am no expert in any of this, but I do agree. I feel like there should be more presented to the board on this if you're asking us the major decisions such as this. And I'm just really just here trying to figure out what our next steps is with this whole process.
Okay. Ms. Allen, do you have anything else to say?
Well, I think most of the people have said most of the things that I feel, but I think it's very serious and we should give great consideration to this matter.
Mr. Banahan, you have your hand up?
Before my hand, I know Joe Soka have the hand before me, Mr. Chair, if you want to talk to him first.
Okay.
Well, listen, if you got anything to say, I'm just going to bring the motion again, Albert.
Okay, and I'm going to talk about that in a minute. So, Albert, what do you have to say?
Yes. I just want to be clear.
Hang on.
I just want to be clear and to everybody understand, be on the same page, that if she don't want to be part, if you don't want to come into the meeting, she want to speak, okay, we respect that decision. If she did it wrong and if she break the policy and the protocol and everything, and you guys have the proof and everything, you know, she did it, I understand she needs to be terminated. But I just want to be sure in the way I see it myself, we can give her opportunity, she can speak and talk, we can hear her side. But if she refused to do it, we respect that. And Mr. Testani, you don't need to apologize because I know you're trying to do the best you can and do the job and the best thing for our kids in Bridgeport School. I just want to be sure that, and I'll be very clear, if she break the policy and the protocol, and then she's wrong, she's wrong. You know, but I just want to be clear myself. If she want to come and speak and defend herself, you know, I would love to hear that. But if she don't want to do it, it's fine. That no more question, Mr. Chair.
Okay. So with respect to any motion that's made, I just want to be clear. This is a special meeting, and the special meetings are very limited as to the action we can take. We can only take action on the actual agenda item. And this agenda item is concerning possible action concerning the termination of the contract of employment. I don't believe
Okay,
that
Mr. Chair, I would
Hang on,
like to,
please,
this point of order.
hang on.
This is an
Stop.
ancillary
Stop.
motion.
Stop.
It's an ancillary motion, Mr. Chair. It's an
This is
ancillary
FOI,
motion. It's
it's not
not a new
Robert's
motion
rule.
on a new agenda item.
Can you
You
listen to me, Joe? Please?
All right, finish, please.
What I'm saying is, the other choice you have is to take no action and let the superintendent take your sentiments back, and he can do one of several things. He can try to enter into a separation agreement. He can try to bring it back to the board with the employee, if the employee is agreeable to it. He can do any one of a number of things. But it sounds like the predominant sentiment is that the majority of people here do not seem to want to take an action to terminate the employment. Is that a fair enough statement?
Not a
You
fair
wanted-
enough statement. Not a fair statement from my
Okay.
perspective.
What's not a fair
The
statement?
statement that look, I am telling you that the actions that are being alleged here are serious, are highly improper, but I have not been provided with anything other than, hey, trust me, we know what we're telling you. That's the only thing I've been told for me to make an informed decision. So what is lacking here is enough information for me to make an informed decision that lets me sleep at night knowing that I took a fair, appropriate disciplinary action or vote on this matter. That's a fair statement.
Mr. Chair, I'll make it easy. There doesn't need to be a motion. There doesn't need to be anything. I will regroup with the Human Resource Department. We will send a notice to the employee. We'll set up another special meeting. You guys can hear directly from the employee, and then we can go from there. At this point, if that's what you want, I'm more than happy to do that, and you can formulate your own decision. That employee will not go back into a Bridgeport Public School building until that meeting is held. And I'm not sure what will happen after that either by the State Department of Ed, but you guys will have the opportunity to hear from the employee if she so chooses to report on that evening. Are we okay with that?
Satisfied with that, Joe?
I would like to be clear what I'm looking for. I'm leaning towards termination. I'm not trying to keep an employee, a bad employee or whatever have you. But what I'm just looking for is constructive receipt of the refusal to attend the meeting.
Okay.
Constructive notification. I'm also looking for something in writing from either one of the teachers or even one of the parents saying that their name is on this thing as having attended a meeting and that they did not attend.
Okay.
That would prove fraud in my eyes. Right now, all we got is, or even some of the teachers that was listed on there, perhaps Ms. Dixon's notes. And I think in the future, it'd be best to, anything like this that is presented, have such items available for us so we don't end up doing this again.
Okay.
Does that sound fair to everybody?
I agree, Mr. Joe. I agree.
Mr. Chair,
I agree.
One at a time.
I agree.
Okay. Mr. Taylor, does that?
I have my hands up on an unrelated matter. I apologize. I've heard everybody call this an egregious, she broke federal law, she broke state law. Why hasn't it been reported to the State Board of Education the moment it happened?
Why?
Yes.
Because we're trying to work with the individual that maybe then with some remorse and some reflection, if they did decide to go and get another job somewhere else, we wouldn't prevent that individual from having a fresh start somewhere else.
Well,
but
I would kind of disagree. I think if something like that happens, I almost feel like you're obligated.
Well, John, that's what I'm getting at. This sounds kind of like an extortion effort. If this was an egregious crime that broke federal and state law and you didn't report it when it happened, but now you're going to report it because we didn't terminate her, that to me sounds like extortion. I don't have a Juris Doctorate. I don't like the way that sounds. It wasn't reported when it should have been reported. I think reporting it now is a retaliatory action, my personal opinion. Guys, this is getting worse by the minute. Let's wrap this meeting up with whatever you guys suggest. I'd like Joe's motion. Let's table it. Let's get her back in. If I would give the, if it is protocol, not to notify the state authorities, it should have been done when it took place, not after having this meeting. It seems like it's now a retaliatory action that, hey, you didn't do this deal, we're reporting you to the state, they're gonna yank your license. I don't like the smell of it.
Okay, I'm gonna say two things. We'll take Mr. Sokolovic's motion to table, and it sounded like you were gonna second it.
Yes, yes, I second it.
That's fine.
And Mr. Weldon, please know, this is one of the few times in life Joe Sokolovic ever agrees with me.
Okay. And I would suggest that council be consulted with respect to the reporting of this to the appropriate regulatory bodies. You really should have that discussion.
And Mr. Chairman, they should get those 3 students IEPs tomorrow because they've made it such a big deal that they didn't have them. That should be priority 1 of this board, is to make sure.
Whenever else we meet, I think, Dr. Raiola, you should be prepared to be able to speak to that. Okay? All right, so we're going to table this item, or rather, I think you're going to postpone this.
Postpone.
Is that fair enough? Attorney
Yes.
Dugas, postpone it?
I agree.
I agree.
Attorney Dugas,
I agree.
hang on.
Yes, sir.
That's fair, that's appropriate. We're not violating anything.
Table, no, I think that's appropriate.
No, to postpone it to another meeting to be held.
Yes, that's fine.
So we're going to postpone this to another meeting to be held in the future. All in favor?
Aye.
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 Opposed? Any abstentions? Okay. Motion carries. This item will be postponed to a meeting sometime in the future. Is there a motion to adjourn?
Motion to adjourn.
So moved.
Second.
Okay.
Aye.
In favor? Well, wait a minute. Before we seal this, Mr. Testani, Ms. Dixon, do you have any questions before we go away?
No, sir.
Raiola?
I have nothing. No, thank you, though.
Okay. All right, then, all in favor?
Aye.
Aye.
Opposed?
Good night, everyone.
Thank you. Good night.
Meeting is adjourned. Time is noted as being 8:09 p.m.
Good night, everyone. God bless you all.
Thank you.